Hi guys, welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Now, today we continue with our discussion on shares of stock, which I started with last episode, okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law, okay? Now, last episode, I talked about the nature of share of stock as well as the different classifications of shares of stock. Okay? Now, the share of stock itself, that constitutes property distinct or different from the capital or tangible property of the corporation. When we talk about shares of stock, that belongs to the different owners. Okay? And the property of the corporation belongs to the corporation itself by virtue of the separate juridical personality of the corporation from its stockholders. Okay? Now, stocks are incorporeal in nature, meaning they're intangible. No, you cannot touch a stock. And as I said, that stock does not, ownership of that stock does not mean you're also the owner of the corporate property. Okay? So, while stocks may be incorporeal or intangible, they are still personal property. And since a share of stock is incorporeal, there has to be a physical manifestation of it. And it is evidenced by a certificate of stock or a stock certificate, no? A stock certificate is simply a written acknowledgement by the corporation of the interest, right, and participation of a person in the management, profits, and assets of a corporation. Okay? It's not the stock itself. The stock certificate is not the stock itself. It is merely a formal written evidence of the holder's ownership or interest in one or more shares, and it is a convenient instrument for the transfer of title. Okay? The stock certificate acknowledges that the person named in such certificate is the owner of a designated number of shares of the corporation's stock, and is that certificate that is prima facie evidence that the holder is a stockholder. Okay? Now, while a certificate is not necessary to make a person into a stockholder, every stockholder has the right to have a proper certificate issued to him as soon as he has complied with all the conditions which entitle him to the issuance of a certificate. Okay? So, a formal certificate of stock can be issued only upon compliance with the following requirements, no? First, the certificates, they must be signed by the president or vice president and countersigned by the secretary or assistant secretary and sealed with the seal of the corporation and issued in accordance with the bylaws. Okay? Next, the certificate itself must be delivered. Next, the par value in case of par value shares or the full subscription in case of no par value shares, they must be fully paid. Okay? And finally, in case of a transfer, the original of the certificate must be surrendered. Okay? So, a stockholder is entitled to the issuance of a certificate of stock as soon as he has fully paid for the subscription. Now, Section 63 says that a certificate of stock can only be issued to a subscriber if he pays the full amount of the subscription together with interest and expenses if any is due, especially in the case of delinquent shares, no? Section 65 says that subscribers to stocks shall be liable to the corporation for interest on all unpaid subscriptions from the date of the subscription, if so required by and at the rate fixed in the subscription contract, or if none is fixed, then at the legal rate of interest. Okay, take note of that. So what the subscriber really has to pay is the balance, no? And Section 65 tells us when payment should be made. Payment of unpaid subscription or any percentage thereof, together with any interest accrued, shall be made on the date specified in the subscription contract or on the date stated in the call made by the board. Okay? Now, when we say call, Okay? That's just a declaration officially made by a corporation, which is usually expressed in the form of a board resolution. Okay? And in that board resolution, there is a call requiring payment of all or a portion of a stock subscription. Okay? For a call to be valid, no, it must be made in the manner prescribed by law, it must be made by the board, and it must operate uniformly on all of the stockholders. Okay? The need for a call depends on the provisions of the subscription contract or if there is no time fixed for payment. Okay? So if the subscription contract provides for a time of payment, then just follow that. But if there is no time fixed, then of course, the board has to make a call, okay, for payment. If a call is needed, and notice of that call is not given to the stockholders, then it is as if there is no call at all. Okay? So notice of the call must be given. So the board of directors may at any time declare due and payable to the corporation unpaid subscription, and they may collect the same or such percentage thereof in either case with accrued interest, if any, as it may deem necessary. So it's within the wisdom of the board to make a call for payment. Okay, subject of course to the terms of the subscription contract. Again, if the time of payment is stated there, just follow that. But if it's not stated, if the time for payment is not stated, then it's the board may at any time, as it may deem necessary, call for the payment. No? Now, if the stock subscription is unpaid, the corporation has different methods to collect the unpaid amounts. No, it can. The first one is through call, then delinquency and sale at auction of delinquent shares. It can also collect the unpaid amounts through an ordinary court action that's expressly provided for in the code. No, it can also collect from cash dividends and other amounts due to the stockholder if allowed under the bylaws or under their agreement. Okay? Now, of course, if the subscriber fails to pay the entire balance due and payable, then he is not only liable for that balance, but also for the interest at the rates that I just mentioned earlier, no? Meaning the interest rate stated in the bylaws or in the interest rate, the legal rate of interest if none is stated. Okay? Now, the interest will be computed from either the date specified until full payment of the subscription or depends on the agreement, okay? Or from default, no? If no payment is made within 30 days from the sale, no? From the specified date, all the stocks covered by the subscription shall become delinquent and subject to sale under the following the procedure provided by law. Okay? Unless, of course, the board says, no, okay na yan. Let's give him some more time. Okay? And Section 66 is important because it gives us the conditions for stocks to become delinquent. Okay? So, stocks become delinquent upon the failure of the holder to pay the unpaid subscription or balance within 30 days from the date specified in the contract of subscription or the call made by the board. Okay? And delinquency is important because there are effects, no, under Section 70, the effects of delinquency. No delinquent stock shall be voted for. No delinquent stock shall be entitled to vote or be represented at any stockholders meeting. The holder of delinquent stock will not be entitled to any rights of a stockholder except the right to dividends. Okay? He will not be entitled to any of the rights, no, until and unless payment is made by the holder of such delinquent stock for the amount due on the subscription. Okay. Now he is entitled to dividends. Why? The law allows this because from the dividends that are distributed, the corporation will use those dividends and apply it to his unpaid balance, no? Take note that before delinquency, Section 71 says that holders of subscribed shares which are not fully paid, okay, and which are not delinquent, they shall have all the rights of a stockholder. So you have to determine, no? if a stock is delinquent or not in order to determine the corresponding rights of the stockholder. Also, take note under Section 42, any cash dividends which are due on delinquent stock shall be first applied to the unpaid balance on the subscription plus costs and expenses. Okay? While stock dividends shall be withheld from the delinquent stockholder until their unpaid subscription is fully paid. I mentioned this na earlier. Okay? Again, the reason why dividends are not withheld from the stockholder, the delinquent stockholder, is so that those dividends which would have gone to him will just be applied by the corporation to the unpaid subscription until it will be fully paid. Okay? Now, what happens to delinquent shares? Under Section 67, they may be sold at public auction. And how does it work? First, the board has to make a call, meaning it passes a resolution declaring payable the whole or a certain percentage of the unpaid subscriptions. Okay? It should state the date fixed for payment. Okay? The stockholder will be given notice. He must be given notice of the call. If the date for payment is specified in the subscription contract, then again, I mentioned this earlier, no call is necessary. And if the stockholder does not pay within 30 days from the date specified either in the subscription contract or in the call, then that's the time that the stocks become delinquent. Hindi matik ha, 30 days. Then that's the time the stocks become delinquent. From then, the corporation will now fix the date, the time, and the place of the sale, which shall not be less than 30 days nor more than 60 days from the date that the stock became delinquent. After that, the corporation should give notice of the sale either personally or by registered mail or other means provided in the bylaws. And the corporation must also publish the notice once a week for 2 consecutive weeks in a newspaper of general circulation in the province or city where the principal office is located. So take note, 2 notices. First notice, call. Second notice is notice of the sale. Okay? And both must be given to the stockholder. Now, if the stockholder wants to prevent the sale, then he should pay on or before the date of the sale the balance due on the subscription plus accrued interest, cost of advertisement, and expenses of the sale. Okay? If not, then the shares will be sold at public auction to the highest bidder. And who is the highest bidder? He is the person offering to pay the full amount of the balance on the subscription together with accrued interest, cost of advertisement, and expenses of sale. This is the important part, for the smallest number of shares or fraction of a share. Now, what does this mean? De Leon in his book gives a good example, no? So, let's say X subscribed to 5 shares with a par value of 100 pesos each, paying 300 as his initial payment, no? The balance of 200 pesos was called in by the board, and X failed to pay, so his stock was declared delinquent. Okay? The interest, expenses, and cost of the sale are 50 pesos for a total of 250 pesos. So now we have bidders at the public auction. So it's A, B, and C. A offers to pay 250 pesos for 2 shares. B offers to pay 250 pesos for 3 shares. And C offers to pay 250 pesos for 4 shares. Who is the highest bidder here? A is the highest bidder. Why? Because he offered to pay the full amount of the balance on the subscription with interest and cost of the sale for the smallest number of shares. Okay? Because again, A offered to pay 250 for only 2 shares. Mas maraming shares yung gustong bilhin ni B and C. Kaya si A ang highest bidder. He's buying the least for the most amount of money. Okay? So what will happen now? Okay, so X will retain the 3 shares and A will now own 2 shares, and all the 5 shares will now be deemed fully paid as far as the corporation is concerned. Okay? Now, after the delinquent stock has been sold, these shares shall be transferred to the highest bidder in the books of the corporation, and of course, he will now be entitled to the issuance of a stock certificate. Okay? Now, what if there are no bidders or there's no highest bidder in the public auction? then the law allows the corporation, okay, to purchase for itself the delinquent stock. In such a case, the delinquent subscriber shall be released from liability with regard to his subscription, which shall be deemed fully paid, okay, in the books of the corporation. Now, take note that the corporation can only purchase such delinquent stock if it has net earnings. Why? Because of the trust fund doctrine. Okay, just keep going back to the trust fund doctrine. Now, these shares purchased by the corporation will now become treasury shares, which I discussed in the last episode. Now, can you question the delinquency sale? Yes, okay, but the period to file the complaint questioning the sale, the public auction, no, is only 6 months from the date of the sale. Together with the complaint, the party who protests the sale should first pay or tender to the party holding the stock the sum for which it is sold, with interest from the date of the sale at the legal rate and a legal rate of interest. And he only has 2 grounds, okay? Either irregularity or defect in the notice of sale, or irregularity or defect in the sale itself. Sa notice o dun sa sale. Okay? Irregularity or defect. Okay? So that's it for payment of the subscription. What if you don't pay? What happens in delinquency sale, etc. Okay? Now let's talk about transfer of stocks. Now, a stockholder has an absolute and inherent right as an incident of ownership to sell and transfer his stocks at will. Sa kanya yun eh. Okay? So he can sell it if he wants. Except as may be restricted by law, as may be restricted by the articles, the bylaws, or the agreement between him and the corporation. Okay? Section 62 expressly authorizes the transfer of shares represented by the certificate, by delivery of the certificate or certificates endorsed by the owner, his attorney in fact, or any other person legally authorized to make the transfer. Okay? Take note, ha? I will clarify, no? As mentioned, the corporation may impose restrictions, but not prohibitions. Restrictions and prohibitions are different. Okay? So, provisions which prohibit a transfer of stocks without the consent, kunyari, of all the stockholders, without the consent of the president, or a provision which says that the transferee must first be approved, kikilatisin muna ng board, or a provision which states that the stocks are absolutely non-transferable. All those provisions are void. The corporation may restrict but not prohibit transfer of shares in its bylaws. Okay? So, the rule is different in closed corporations, because closed corporations, the transfer of stock really has restrictions, no? But we'll talk about closed corporations in a different episode. For now, we're just talking about regular stock corporations, okay? So, for a valid transfer of stocks, there must be delivery, of course, of the stock certificate. The certificate must be endorsed by the owner or his attorney in fact, or other legally authorized person. And finally, the transfer must be recorded in the stock and transfer book. Okay? So, that said, no, a stock certificate is quasi-negotiable in the meaning it's not really a negotiable instrument. I discussed this in partly in my negotiable instrument series. You can watch that, no? But it is only quasi-negotiable and it is not a negotiable instrument. It's quasi-negotiable because title can be transferred by endorsement, okay, but it is non-negotiable because the holder takes it subject to the defenses of the registered owner or the transferor's creditor under the law, except in case of estoppel, no? So, it's subject to the defenses, okay? Just remember, endorsement coupled with delivery is necessary. Okay? And that it will only bind the transfer will only bind the corporation when the transfer is recorded in the corporate books, no? Yung stock and transfer books. In other words, no? As between the parties to the transfer, the immediate parties, no? The transfer is valid. It's valid between the parties as long as there has been endorsement coupled with delivery. But to bind third persons and the corporation, the transfer of that stock must be entered and noted in the books of the corporation to show the name of the parties, the date of the transfer, the number of the certificate, and the number of shares which are transferred. Okay? However, since the law uses the word may, no? May meaning it's permissive and not mandatory as contrasted with must or shall, no? Since the law uses the word may, shares of stock may also be transferred in a different way, such as assignment, no, in a separate instrument, unless of course the bylaws expressly provide that the transfer shall be made exclusively in the manner provided for by law. Okay? Also, in case of death, no, without a will, the heir will have to wait for the estate of the deceased to be settled and the stocks to be registered in his name in the stock and transfer books before he can be considered a stockholder. So before the transfer is registered in the stock and transfer book, the heir of the deceased cannot say, hey, I have the right to vote. Hey, no, he has no rights yet. He's not yet a stockholder until the transfer is recorded in the stock and transfer book. Now, the requirement of registration in the stock and transfer book is required only for absolute transfers, meaning ownership has passed to the transferee absolutely. Okay? When it comes to pledge or mortgage of shares, no, before the Personal Property Security Act is in operation, no, when it comes to pledge or mortgage, registration in the books of the corporation is not necessary, and public instrument or registration in the Chattel Mortgage Registry is enough. Okay? Or in case the Personal Property Security Act applies, then just compliance with the requirements of that law will be enough. Okay? You don't need to register it in the stock and transfer book. Why? Because those contracts, no, are contracts of security and they do not transfer absolute ownership. Okay? Only those absolute transfers are required to be recorded in the stock and transfer book. Okay? Now, registration in the stock and transfer book is required to enable the corporation to know at all times who its actual stockholders are. Why? Because mutual rights and obligations exist between the corporation and the stockholders. Okay? So, you have to register the name in the stock and transfer book so that the corporation knows who its stockholders are. Another is to afford the corporation an opportunity to object or refuse its consent to the transfer in case it has any claim against the stock sought to be transferred or any other valid reason. Okay? Another would be to avoid fictitious or fraudulent transfers. No, those are the purposes of registration in the stock and transfer book. Okay? Now, failure to register the transfer of shares will still result in a valid and binding transfer, but only between the parties. Okay? Only between the parties. Again, with regard to the corporation and third persons, it does not exist except where notice is given to the corporation for purposes of registration. In which case, the transferor still has the right to vote and be voted for and can still participate in any meeting and has the right to receive dividends. But if the transferor receives dividends, he holds it in trust for the transferee. All because the corporation will not yet recognize the transfer until it has been recorded. Okay? Kumbaga, huyo ka sa akin. Huyo ka dun sa transferee. Register ka muna, then okay, I know you na. Now, what if the stock certificates are lost or destroyed? What's the remedy of the owner? First off, this is important, no? That's why I want to lead with this. A finder of a lost certificate or someone who steals a stock certificate, he does not become the owner of that certificate or of the stocks. Okay? And he cannot vest in his transferee, supposing he transfers it to someone else. He cannot transfer a valid title. Okay? He cannot transfer a valid title from a certificate which he found or which he has stolen. So even if the transferee acquires that lost certificate or stolen certificate for good faith, in good faith and for value, then he does not still get a valid title. Okay? Because remember, stock certificates can only be transferred through endorsement coupled with delivery, and to bind the corporation and third persons, it must be recorded in the books of the corporation. Okay? So if a person who owns stock loses his certificate, a new one may be issued to him. But he must first file with the corporation an affidavit in triplicate, no? Stating the circumstances as to how the certificate was lost, stolen, or destroyed, the number of shares represented by such certificate, the serial number of such certificate, the name of the corporation, and other information and evidence as may be necessary. Okay? So, after verifying the affidavit and other information and evidence with the books of the corporation will now publish a notice in the newspaper of general circulation in the place of the principal office of the corporation once a week for 3 consecutive weeks at the expense of the registered owner, okay, of the certificate which has been lost, stolen, or destroyed. Siyempre, humihingi siya ng kapalit, bayad ka. Okay? Now, the notice which will be published, no, should state the name of the corporation, name of the registered owner, serial number of the certificate, the number of shares represented by the certificate, and this is also important, no? There should be a statement that after the expiration of 1 year from the date of last publication, if no contest has been presented to the corporation regarding the certificate of stock, then the right to make such contest shall be barred. Okay? And the corporation shall cancel the lost, destroyed, or stolen certificate of stock, and the right to make such contest, and wala na, it's lost. Okay? And the corporation can now cancel the lost, stolen, or destroyed certificate of stock. Okay? So in other words, if anyone wants to contest the issuance or protest the issuance, they have 1 year to do so. Okay? And the person applying for replacement has to wait 1 year before a new certificate is issued to him. Okay? Because the law says, in lieu of the lost, stolen, or destroyed certificate, the corporation shall issue a new certificate of stock unless the registered owner files a bond or other security as may be required, effective for a period of 1 year for such amount and in such form and with such securities as may be satisfactory to the board, in which case a new certificate may be issued even before the expiration of 1 year provided in the law. Okay? In other words, no, if you're having a hard time reading the law, just because it's so long, just chop it up into sentences that or phrases that you can understand. In other words, if the owner wants a the certificate of the certificate of stock earlier than 1 year, then he has to file a bond or other security, okay, with the corporation. Okay. Now, if a contest has been presented to the corporation, or if an action is pending in court regarding the ownership of the stock certificate which has been lost, stolen, or destroyed, then the issuance of the new stock certificate shall be suspended. Okay? Huwag ka muna mag-issue until the court renders a final decision regarding the ownership of the stock certificate which was lost, stolen, or destroyed. Okay? Common sense, no? Let the court decide muna who really owns it. Don't give new stock certificate to someone that you're not sure is the real owner. Okay? And take note that except in case of fraud, bad faith, or negligence on the part of the corporation and its officers, no action may be brought against any corporation which shall have issued certificates of stock in lieu of those lost, stolen, or destroyed. Okay? Following the procedure that I just explained. No? This just means that the corporation will not be held liable to any person who is prejudiced by the issuance of the new certificates of stock if they follow the procedure. No? The only time the corporation may be held liable is if there is fraud, bad faith, or negligence on the part of the corporation and its officers. Okay? So that's it for stocks, no? And part 2 of the discussion on stocks, no? So I hope you may have picked up a thing or two, And see you next time, guys. Okay? See you soon. Bye.